1 year ago, an unknown person kicked off a firestorm by leaking a draft of a Supreme Court ruling on abortion. The ruling, published by Politico, suggested a legal earthquake was coming as the justices were poised to overturn Roe v. Wade. Just this week, Supreme Court Justice Samuel Alito told the Wall Street Journal he has theories about who leaked the draft and why. In a moment, my panel of legal insiders, including multiple former Supreme Court clerks, joins me live. But first, a look at what happened once that draft went public.
Roe v. Wade is going to go. He won't go back.
Pro-choice and pro-life groups flooded the streets in front of the Supreme Court as soon as the high-stakes draft ruling leaked. And demonstrations didn't stop there.
We say pro-choice.
As abortion rights groups protested outside the Republican-appointed justices' homes, the justices themselves were stunned at the breach of trust the leak exposed.
It was beyond anyone's understanding, or at least anyone's imagination, that someone would do that.
Chief Justice John Roberts quickly ordered the court's marshal to conduct an internal investigation. But after 8 months, a public statement from the court indicated the marshal was not able to find the leaker or figure out how they did it. The 9 justices left with the fallout.
Look where we are, where now that trust or that belief is gone forever. It changes the institution fundamentally. You begin to look over your shoulder.
And in the months after the end of Roe, Gallup polling showed Americans' trust in the court dropped. When asked that summer about the polls, one of the justices who dissented from that landmark opinion sought to reassure.
We have to have continuing faith in the court system, in our system of government, continuing the battle each day to regain the public's confidence.
We have assembled a powerhouse legal panel to talk about the court 1 year after that leak and now facing new ethics questions. Judicial Crisis Network President and former Clerk for Justice Clarence Thomas, Carrie Severino. Constitutional Accountability President Elizabeth Wydra. George Washington University law professor and former Clerk for Justice Thurgood Marshall, Stephen Salzberg. And legal partner at Cooper & Kirk and former Clerk for Justice Samuel Alito, Megan Wohl. Thank you all for giving us your time today. We appreciate this. 1 year out, we still have more questions than answers, most of us. I want to read something from the Wall Street Journal. Justice Alito, speaking out this week about this, said, "I personally have a pretty good idea who is responsible. It was part of an effort to prevent the Dobbs draft from becoming the decision of the courts, and that's how it was used for those 6 weeks by people on the outside as part of the campaign to try to intimidate the court." Megan, you clerked for the justice. What do you make of his comments and where we are a year later?
Well, apparently, we will never know who leaked this draft opinion in the Dobbs case. Obviously, the standard for stating a name, as Justice Alito said, is very high. But it's very clear what the intention of this person was. It was to influence the outcome of Dobbs, to change that decision. And the effect was predictable. We saw immense public pressure on the justices, including protests outside of their homes, threats on their lives, and one man appearing at Justice Kavanaugh's doorstep with the intent to kill. This ultimately diminishes our confidence for all Americans. It really affects all of us because this person had a vigilante impulse. What they couldn't accomplish within the law, they decided to try to accomplish outside of it.
He also talks about the frustration of finger pointing at potentially the conservative justices or somebody that would support their position, saying essentially they became targets of assassination, Carrie.
Absolutely. I think this is why it's clear this wasn't someone from the right who would do this. It's everyone had from day one has understood that the goal here to try to change the opinion was something that would come from the left, and the threats were obviously targeted at the conservative justices, up to and including a threat of assassination, doxing of the justices, doxing of where they attend church, where their children go to school. This is really a serious problem for the justices' safety and obviously for the internal workings of the court.
And a lot of frustration because we never got those answers. From the Supreme Court's public release when they talked about the investigation in January of this year, some individuals admitted to investigators that they told their spouse or partner about the draft Dobbs opinion and the vote count in violation of the court's confidentiality rules. Professor, as somebody who's clerked there, did that surprise you at all?
It did surprise me. The justices, at least when I was there, made it very clear they trusted you. And you weren't to talk to anybody about what was going on until an opinion was announced. And I think we adhered to that, and we understood how important it was.
Elizabeth, do you think we're ever going to know? And what is your thought about the long-term impact on people being able to trust the court and what goes on there?
Yeah, absolutely. You know, I think that the leak has had, you know, a really enormous impact on the court itself and the inner workings of the court. I think that, you know, we've seen, as Justice Thomas said, you know, in your intro, distrust inside the court. But I think if we look outside the court, I think the leak itself was not really what's caused these changes in poll numbers of having faith in the Supreme Court. I think it's really more about what was in the draft opinion that was leaked, because I think probably if you think about Americans who are working hard, trying to put food on the table, take care of their kids, you know, they probably aren't following the leak story super closely, but pretty much everyone knows that Roe versus Wade was overturned.
And one of the criticisms came with the specific reference to Justice Thomas's concurrence in Dobbs. I know the people who object not only to the broader ruling, but that as well. He said this: in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. Here's what President Biden said that day about that portion.
Justice Thomas said as much today. He explicitly called to reconsider the right of marriage equality, the right of couples to make their choices on contraception. This extreme and dangerous path the court is now taking us on.
Carrie, we've heard those words used a lot. Extreme. This court can't be trusted. It's illegitimate.
Yeah, I mean, so the legitimacy attacks, I think, are really just amount to name calling. We know that these justices were all legitimately appointed by the president, confirmed by the Senate. I think one of the unfortunate things about that concurrence is it's allowed people to demagogue about issues that are not what the opinion is actually about. Justice Thomas frequently writes concurring opinions that talk about other theories that maybe he's the only one on the on the court to hold, and certainly aren't what's going on before the case. The court and the opinion made very clear is clearly limited to abortion, and I think it's also very clear that while Justice Thomas is willing to consider rethinking substantive due process, doesn't mean some of those rights might not come in through other areas, because Justice Thomas believes in the Privileges and Immunities Clause, which other justices don't follow, right? But that there certainly aren't a large number of votes for that on the court right now. I think most of this is just demagoguing and trying to change the subject from the limited nature of that opinion itself. It's clearly significant, but it doesn't have the impact that some people are trying to penny about.
Well, he's been in the headlines, as many others have been recently. Here are some of them on ethics questions. ProPublica saying Clarence Thomas's secret life of luxury. Vanity Fair, whoops, Neil Gorsuch also made big money from a dubious real estate deal. Politico, Jane Roberts, who is married to Chief Justice John Roberts, made $10.3 million in commissions from elite law firms, whistleblower documents show. Professor, what do you make of these calls for the court now to step up, draft, adopt a code of conduct?
I think it's long overdue for the court to have a code of conduct, and these revelations are historic. You look back, aside from Abe Fortas, who his conduct involved $20,000 on a payment, you look at the history, the Supreme Court's been great about avoiding financial improprieties and the like. And this has called into question, I guess, for good reason, the ethics of this court.
The Federalist says this, though. They say the only thing that matters is creating the perception that conservative justices are corrupt. It's all part of a concerted effort to delegitimize a Supreme Court that still occasionally upholds a semblance of constitutional limits on the state, the one thing still standing in the way of progressive progress. Megan, what do you make of that, of these headlines, of these questions?
The headlines are really political mudslinging. The justices here didn't do anything wrong. Some of them accurately reported transactions, and some of them didn't report things that no one would have to report. The purpose is exactly what that article said. It's to influence the outcome of the court, and to do so illegitimately. There are Democrats in Congress who want to impose restrictions on the justices in order to exert more control over their lives, over the lives of their spouses, and ultimately to influence outcomes. Because if justices need to recuse themselves, there's no one to take their place, and so it really affects the makeup of the court and how cases are decided.
Yeah, and so Elizabeth, this is coming against the backdrop of a bipartisan call now in the Senate. There's a bill coming together to force the justices to write and adopt this new code of conduct. But there's an interesting opinion piece in the Washington Post that said it's possible that that is one branch infringing on another, and they really are separate for good reason, and that there are corruption laws, there's impeachment for the justices, they're still subjected to those kinds of things.
So we have checks and balances in the Constitution, and the Supreme Court is obviously subject to checks and balances, just like the other branches of government. And it's required under the law that we have both the appearance and the reality of impartiality when it comes to our judicial branch. And the Supreme Court, as the highest court in the land, should be even more true. And so I think the idea that they aren't bound to an ethics code in the same way that every lower federal court judge is, perhaps suggests that the appearance of impartiality, and we'll put aside the reality for a moment, is not really getting through to the public. And so I think it is really something that is appropriate for Congress, doing its oversight authority, engaging in its oversight authority, to consider whether reforms need to be made or not.